The Criminal Court Process, a presentation by Adam Goodman, barrister and solicitor. For a free consultation, please call Adam at 416-477-6793. This presentation will apply only for summary conviction offences. These are offences that are generally less serious and carry smaller penalties. However, the Criminal Code provides that most offences are of a hybrid nature. This gives the Crown the right to choose if they'd like to proceed by indictment or by summary conviction. The vast majority of cases are proceeded by way of summary conviction. These cases, the trials take place by judge alone in the Ontario Court of Justice, with appeals going to the Superior Court of Justice. Please note that this slide shows appeals only to summary conviction offences. However, in the case of indictable offences, there are a number of similarities in the way the case will proceed through the court system. Following an arrest, the police will determine how that person is to be released, if at all. Firstly, they may issue a summons. A summons is usually a small yellow ticket which requires the person to appear in court on a certain date. They may also bring the person back to the station and create what is called a promise to appear. The promise to appear may or may not contain certain conditions that the person will undertake to comply with. The conditions might include things such as a curfew, boundaries, or depositing a passport. The alternative is the police may decide to have the person go to court for a bail hearing or a show cause hearing. In this case, it will be up to the judge or justice of the peace to determine if this person shall be released from custody or should wait in custody pending their trial. A bail hearing, which is more formally known as a show cause hearing, is a formal court hearing whereby a justice of the peace or judge will make a determination whether a person should be released into the community. In making this determination, the justice of the peace or judge will consider the plan of release that has been presented by the accused person. This plan will almost always involve the assistance of sureties. Sureties are usually friends or family members of an accused person who are prepared to pledge a certain amount of money to ensure that they come to court and they abide by certain conditions, as well as to assist in supervising the accused while they are out in the community. There is a separate presentation available for bail hearings, and I would encourage you to go and view this presentation if you are looking at a bail hearing for an accused person. Now, getting into the actual charges and how to face the charges, because unfortunately the bail hearing isn't the end of the process. There'll be what's called a first appearance, and somebody will be giving a first appearance date that they'll have to appear in court on. If you hire a lawyer, often the lawyer can go for you, but if you don't, you do have a responsibility to go, and not going can result in a new criminal charge of fail to appear. Ideally, the Crown will have some disclosure available at the first appearance. An accused person has the right to know all of the evidence that the Crown is going to be using to prosecute them, and disclosure is what this evidence is. The reality is, often this isn't available at all in the first appearance, and somebody will have to come back. Or there might be things that are missing. For example, there might have been a video that was taken, and an accused person has the right to view these videos, and often these need to be requested. In addition, there will be a charge screening form that's included with the disclosure, and the charge screening form is essentially the Crown's initial position on how this charge is going to be dealt with. It might include if it's going to be by summary or indictment. It might suggest what some possible consequences the Crown is seeking on a guilty plea, and if there's other possibilities of resolving without a guilty plea, these are usually noted in the Crown screening form, but sometimes a lawyer might be able to negotiate these with the Crown attorney. Speaking of some options for resolution without trial or guilty plea, often the best option is a diversion program, and this involves an accused person doing a number of things. Might include a class, might include some community service or a charitable donation, and after these things are done, the Crown will withdraw the charges. Diversion is usually only offered for less serious charges, such as theft like shoplifting or possession of cannabis. It's usually only offered once, so if somebody's arrested subsequently, they're probably not going to be offered diversion. And it might require some acceptance of responsibility, and this often concerns people for immigration and employment reasons. Secondly, there might be an option to sign a Section 810 peace bond, or possibly also a common law peace bond. And what this is an agreement to keep the peace and be of good behavior and to abide by other conditions. A common one is to stay away from a certain person without their consent, which would be written and revocable orally. Peace bonds generally apply for 12 months. It is a criminal offense to breach the terms of a peace bond, which would bring somebody back before the courts. And once the peace bond is signed, the Crown will usually withdraw the charges. A peace bond is, however, a court order, and while it's not a criminal record, there is a record of the peace bond, so if somebody's going to sign that and they're concerned about that record, it's something that they probably want to speak with a lawyer about. Subsequently, there's going to be numerous other court appearances before the matter is dealt with. The court might be waiting for an accused person to retain counsel, so they might go back and forth to court in doing that. Disclosure might be incomplete, so it might involve going back and forth to court until disclosure is ready, and the court might also need to accommodate pretrial schedules of judges and Crown attorneys that sometimes take some time to deal with. At some point during this whole process, there would be a Crown pretrial. And if you have a lawyer, your lawyer will do this for you. But this involves discussions with the Crown attorney about the case. They'll talk about resolution. The lawyer might decide to present some reasons to withdraw the charge or have the Crown agree to a diversion or peace bond. And if these things aren't possible, what it will do is it will narrow down some of the trial issues and it will determine how long a trial might take. It might also be determined that some assistance from a judge by way of a judicial pretrial might be helpful. This involves an informal discussion with a judge. This would not be a judge that would be the judge sitting at trial. The judge might be able to offer some assistance with regards to resolution, might also be able to narrow down some trial issues. And if a resolutions discussions do happen with this judge, a plea, if both parties agree, could be entered before the judge at judicial pretrial. Some accused persons determine that a guilty plea is in their best interest. I'm certainly somewhat wary to jump into doing guilty pleas, but sometimes people want to move on with their lives, they want to accept responsibility, or it's possible the Crown might be taking a very reasonable sentencing position, and based on the evidence, a lawyer and the accused person might determine that a guilty plea is the best option. In order to enter a guilty plea, an accused person must be prepared to admit to the facts of the offense for which the plea is being entered. They must be pleading guilty on their own free will, meaning nobody needs to be forcing them to doing it, and they also need to realize they're waiving their right to a trial. If an accused person isn't agreeable to these three elements, a lawyer cannot ethically enter a guilty plea and would have to set a trial date. Finally, the accused person must explain that they realize that although there might have been some discussions with the Crown attorney with respect to sentencing, the decision of sentencing is ultimately at the discretion of the judge by whom an accused person is pleading guilty to. So that's something that needs to be considered in cases where it might be a very favorable sentence position. If there is not going to be a plea, the next step is trial. At a trial, it's up into the Crown to prove all elements of the offense beyond a reasonable doubt. The offense does not need to lead evidence or the defense to the allegation, but they may choose to do so. Accused certainly does not have to testify. However, if they do testify, the Crown does have the right to cross-examine them. Since we're talking about summary charges, these trials will occur before a judge alone of the Ontario Court of Justice, and the final decision on guilt or innocence will be at the discretion of that judge, and then the sentencing options will be with that judge, and I'll have a separate presentation on sentencing available. Any appeals, if this judge does not make a decision that the lawyer feels was correct based on the law or based on their analysis of the facts, are then taken to a superior court of justice, and certainly you should speak with a lawyer regarding doing this. Now, this entire process might take quite some time. It could take a year or two for a matter to get to trial. So it's possible that at a court date where a trial date is set, the trial could be set for several months later. And this depends on a certain jurisdiction and what the backlog is in the court system. There's certainly a right for accused persons to be tried within a reasonable period of time, and if they're not, and unfortunately it's not like there's a set formula where I could say, if don't have your trial within X period of time, then your charges will be stayed. But if it does get to be too long, a lawyer might bring what's called an 11B application, which is Section 11B of the Charter of Rights and Freedoms, and might seek to have the charges stayed on that basis. So again, if you have any questions, you can feel free to give me a call, and I'd be happy to offer a free consultation. Thank you.